a huge step forward to say they will re-examine the sedition law. The CJI then observes what we feel is the state has said they want to do something. It appears we should not be unreasonable. Let us see how much time we need to give. And then there's an affidavit that's been spoken of from the other side where they say there is another disturbing aspect. When the privacy case argument was over, the centre said they are setting up a committee in marital too similar. CJI has noted the Prime Minister's intervention in the matter, which is extremely crucial here to remember. The Solicitor General says, I take instructions, discuss if the guidelines can be made. And Justice Kohli says, as Brother Justice Khan said, why don't you take instructions with the state to not proceed with the matter? Let me tell you, the biggest thing that's happened inside the courtroom as we are speaking is
yeah, go ahead, Rhythm. All right, Rhythm, if you're there, I'm just bringing to your attention the observation made by Justice Hima Kohli, where she has said that, as Brother Justice Kant said, why don't you instruct the states to not proceed with the matter till the issue is under reconsideration? Essentially, the mind of the court is that the sedition law should be used lightly, and in any case, there should be some guidelines that till the time that review happens, no further arrests should be taking place under sedition law across the country, and that the centre should be issuing some kind of guidelines to the states. Is this right insofar as observation made by Justice Kohli is concerned, Rhythm? All right, we lost Rhythm there, but then this is an important comment coming in from Justice Hima Kohli, who's on the bench. It's a three-judge bench, remember, viewers. And apart from Justice Kant, it is Justice Kohli and, of course, the Chief Justice of India, Justice Ramanna. Justice Hima Kohli has said that why don't you instruct the states, and she's supported by Justice Kant, or she's seconding Justice Kant, that why don't you instruct the states to not proceed with the matter till the issue is under reconsideration? To which the Solicitor General added that I will take instructions and discuss if guidelines could be made, essentially meaning that the court is of the view that given the fact that even the Prime Minister wants a review of the sedition law, at least till the time that review happens, all cases where sedition law is applied or Section 124A of the IPC is applied, to be more precise, no arrest should be taking place across the country. So essentially in its soul, I think the court is of the view that the idea of sedition law should be tapered and toned down forthwith, pending a proper review, based on which it would be decided whether the law itself should be written down or should remain part of statute books. And a very important development coming in, viewers, so far as sedition law is concerned, the topmost court of the country clearly pushing the envelope, saying, and if I can continue, after the Solicitor General said that he would be taking instructions from the government. All right, Majid Memon joins us, senior lawyer Majid Memon. So you practice there in Mumbai. The court is giving an indication that pending a review of sedition law, no further arrests should be made, and guidelines to that effect can be made by the centre to the states. But fact of the matter is that the law is used by states and every party is equally guilty of having used it. So in that sense, you think between Prime Minister's words in the affidavit of the centre that sedition law is to be reviewed, and now the Supreme Court taking it further, we are moving in the direction of sedition law finally getting toned down, at least if not fully scrapped in the near future.
Well, I look at this sedition law not from political angle. I look at it as an officer of the court. I look at it in its legal perspective. We believe, and we have been saying this from day one, irrespective of the fact as to who is abusing it, whether it is BJP abusing it or Congress abusing it or anybody else abusing it, is not relevant. What is relevant is the state or the center. If they are abusing law, that abuse has to be resisted, that abuse must go. And for that purpose, since we have found that in the past few years, there has been too often resort to invoking the 124A, even on the drop of the hat. number of people, the journalists, the lawyers, the activists, the political opponents, etc., have become victim to this 124 wrongly applied. You see, therefore, now that the Supreme Court has said that till the law is reviewed, reconsidered by either a larger bench of the Supreme Court or by the centre itself under the instructions of the Honourable Prime Minister, belatedly we have learned yesterday. And once this review takes place, maybe that this law may not survive. This law may be wholly repealed, lock, stock and barrel. And therefore, till then, there should be no arrest under 124A. I think it's a very good move, and that would certainly prevent the abuse of authority by anyone, either at the state level or at the centre.
Right, sir. So you seem to be welcoming this stance by the topmost court of the country that pending a review of the sedition law, no further arrest should be taking place. Thank you so much on that note. Majid Mehman, senior lawyer, speaking from Mumbai. Thank you so much for joining us. Proceedings continue in the topmost court of the country on sedition law, where the government in a U-turn had yesterday, quoting views of the Prime Minister, said that there is possibility that the sedition law should be reviewed, following which proceedings are taking place today, where it seems that the three-judge bench of the Supreme Court is unanimous that pending that review of sedition law,